Good afternoon, everyone. Thank you for joining me here today. I'm joined here also by Vanita Gupta, the head of our Civil Rights Division. Nearly a year ago, the Department of Justice released our findings in an investigation of the Police Department of Ferguson, Missouri. Our investigation uncovered a community in distress, in which residents felt alienated from their own police force and their own local government. The Ferguson Police Department's violations in particular were expansive and deliberate. They violated the Fourth Amendment by stopping people without reasonable suspicion, by arresting them without cause, and by using unreasonable force. They made enforcement decisions based on the way individuals expressed themselves, and they unnecessarily escalated non-life-threatening situations. These violations were not only egregious, they were routine. They were encouraged by the city in the interest of raising revenue. They were driven, at least in part, by racial bias, and they occurred disproportionately against African American residents of Ferguson. And they were profoundly and fundamentally unconstitutional. The government's findings were based upon information received from Ferguson's own citizens, from Ferguson's own records and Ferguson's own officials. And they demonstrated a clear pattern and practice of violations of the Constitution and of federal law. After announcing our findings almost a year ago, we began negotiations with the city of Ferguson on a court-enforceable consent decree that would bring about necessary police and court reform. From the outset, we made clear that our goal was to reach an agreement to avoid litigation. But we also made clear that if there was no agreement, we would be forced to go to court to protect the rights of Ferguson residents. Painstaking negotiations lasted more than 26 weeks as we sought to remedy literally years of systemic and systematic deficiencies. A few weeks ago, the Department of Justice and Ferguson's own negotiators came to an agreement that was both fair and cost-effective, and that would provide all the residents of Ferguson the constitutional and effective policing and court practices guaranteed to all Americans. As agreed, it was presented to the Ferguson City Council for approval or rejection. And last night, the Ferguson City Council rejected the consent decree approved by their own negotiators. Their decision leaves us no further choice. Today, the Department of Justice is filing a lawsuit in federal district court against the city of Ferguson, Missouri, alleging a pattern and practice of law enforcement conduct that violates the First, the Fourth, and the 14th Amendments of the Constitution and federal civil rights laws. We intend to aggressively prosecute this case, and we intend to prevail. The residents of Ferguson have waited nearly a year for their city to adopt an agreement that would protect their rights and keep them safe. They have waited nearly a year for their police department to accept rules that would ensure their constitutional rights and rules that thousands of other police departments follow every day. They have waited nearly a year for their municipal courts to commit to basic, reasonable rules and standards. But as our report made clear, the residents of Ferguson have suffered the deprivation of their constitutional rights, the rights guaranteed to all Americans, for decades. They have waited decades for justice. They should not be forced to wait any longer. Thank you. Do you have any questions?
This is fast. I mean, this is less than a day after the vote, less than a year after the findings report. Why not go back and continue to negotiate? Bankruptcy for a city, it's a legitimate concern. I mean, do you think that bankruptcy is a fair potential consequence for this type of investigation?
What I can say is that throughout the discussions with the city, beginning with the report and going throughout these 26 weeks of negotiation, we were very sensitive to cost concerns. In fact, as you note, you have in your packet information in our January 26th letter, we have provided free technical assistance to them during this time period at no cost to the city. So we've been sensitive to their concerns, and we have discussed this issue with the city. We had come to terms on an agreement to be presented to the city council. That agreement was to be approved or rejected. The city was clear last night that they rejected that agreement.
Madam Attorney General, what was your reaction when you heard that the council had rejected this?
Disappointment. Disappointment that they chose litigation over a faster route that would bring constitutional policing to the police department and the municipal court system.
Hi. What is your understanding of what the sticking points were? What's your understanding of what the sticking points were? Why did the city council vote this consent decree down? What is your understanding of the details of what was problematic?
Well, the city council had public hearings on that, but it's unclear as to whether or not those were the concerns that they were relying upon. You'll have to refer to them as to what their concerns were. What I can say is that after painstaking negotiation, a document was reached in which every detail was discussed by both sides and decided to present that document to the city council for approval or rejection. Every part of that document was discussed and was negotiated extensively.
Thank you. The mayor of Ferguson said today in a press conference that they were willing to negotiate with the Department of Justice. They wanted to put the ball in your court to come to some kind of an agreement. And he also said it was only within the last 2 weeks that the full cost of what the consent decree would mean for the city became clear to him, and that's why they wanted to vote on it. What is your reaction to that? Do you think that there is, would there have been room for negotiation, and why did you decide instead to announce this litigation?
We simply followed through on the discussions that we've had with the city for almost a year, in which we made clear from the beginning that our goal was to avoid litigation and come to a court-enforceable agreement that would provide for constitutional policing and municipal practices. As I indicated, we were sensitive to costs. Those discussions were had. And in fact, as we've indicated, the agreement that was being reviewed and was discussed was painstakingly negotiated by both the department and the city's own team. That was the agreement that was to be decided upon. The city was well aware that by deciding not to accept it, that they were choosing litigation. This is their choice. Actually, I was right behind you.
Ma'am, do you think the estimates that the city's put forward in the last 24, 48 hours are even legitimate? Because they seem to be much higher than what was estimated before. And do you believe this process, which isn't the normal process that you guys go through in negotiating settlements, do you think that was done in good faith by the city?
Well, I'm not going to speak to the process because the city is an independent entity and they're able to set these processes. You're correct, it's not the normal process that we go through. As we indicated to the city, we felt that the city council had before it an in-depth, substantial agreement that they could vote to approve or reject. Had it been approved, we would have filed it in court, and together we would have had a fairness hearing at which the court, a neutral, uninterested, observing non-party, would have been able to listen to these concerns. With respect to the cost estimates that were put forth, again, I'm not going to comment on the specificity of them because they did change, but I will say that, as always, we are always cost sensitive when we deal with municipalities in this. However, there is no price for constitutional policing. The citizens and the residents of Ferguson deserve what every American is guaranteed under the Constitution: the right to be free from excessive force, from unconstitutional stops, from unconstitutional arrests, and from a fine system that was literally breaking their backs.
You said that you were disappointed when you first heard about it, but were you surprised at all, given all the negotiations that happened over the last several months?
Well, we had been negotiating with a team that was responsive. We had had extensive discussions, and so we had, in fact, as you will see from the agreement that was posted several weeks ago, come up with an extensive and detailed document that provided for substantial changes in the city's practices, in the police department's practices, and also in police and community relations. We felt that this was in the city's best interest. It was in the interest of the residents of Ferguson to avoid costly litigation and to, in fact, start working right away on all of these important changes. So my main reaction, as I indicated, was disappointment that they had not taken advantage of that opportunity.
When you do sue and you prevail, assuming you prevail, what does that end result look like? Does it get you back to where you would have been had the consent decree been approved in the first place, and they just then commit again to what they should have committed to last night?
Well, that certainly is one option. Obviously, we will be monitoring the situation throughout the course of the lawsuit to make sure that there are no new problems that rise up in Ferguson. Certainly, we would be asking for injunctive relief and specific relief. You have the complaint there in electronic form. It basically has two causes of action. Of course, Section 14141, the right to be free from excessive force, and of course, discriminatory policing based on race. So we're asking for relief from those actions. We're asking for specific remedies that would give the city, frankly, we still feel they have an opportunity through this court process to come up with systems that would provide a substantial benefit to the city. It is extremely unfortunate that the city has chosen to litigate this matter rather than move directly to these remedies and reforms that would in fact have been proven a benefit to the city and avoided the cost of litigation.
Given that, several of the individuals who were mentioned in the original report were involved in the negotiation process, specifically the financial manager who I believe had come up with some of the estimates of the cost. Do you think that played any influence in the cost estimates or how this proceeded?
I don't have any insight into the estimates in which they used, particularly the varying estimates, so I'm not able to give you that information. What I will say again, as I indicated before, that we do not believe that there is a price to be placed on our Constitution. We think all citizens are entitled to what everyone enjoys by birth in this country: the right to be free from excessive force, the right to be free from discriminatory policing. And we had, before the city of Ferguson, a plan that would have allowed them to start making those reforms right away. Indeed, we had been providing assistance to the city of Ferguson through training and other police technical assistance at no cost to them. And that would have been a part of our ongoing discussions had we gone forward with the consent decree.
Were there any changes that they proposed specifically that were deal breakers for you? What exactly were the biggest issues of the changes they sought to make?
Well, I think you can look at and see the issues that were raised, and I'm not going to go down them in excruciating detail, but what I can tell you is that our view is that the citizens of Ferguson deserve constitutional policing no matter who is in charge of their police force, and to allow the city to simply evade the terms of an agreement, carefully negotiated and presumably had it been agreed to, by simply transferring control of the police department to another state entity, was simply unconscionable to us, and frankly would have meant that this could have been avoided and evaded by them at any point in time. I think that what we have to focus on, again, is our goal, which was to achieve constitutional policing through some specific changes that we felt would have been a real benefit, and we frankly feel that our technical assistance already had been a benefit to the police department.
To what extent is the decision to sue based on the notion that you simply can't have a process where you do pattern and practice investigations and then city councils or some other entity decides to renegotiate after you've already done the negotiation? My question is, how much do you need to set an example of Ferguson that this is not how DOJ will handle these cases?
Well, every case is different. We deal with every jurisdiction on their own terms, and we deal with them openly, and we hope that they deal with us in that way. This message is a very specific one to Ferguson. It is simply a response to their decision. After literally weeks, months, almost a year of discussion, at which point 2 teams had come together with an agreement that was going to provide real relief, it was rejected. And as we had made clear from the outset, in the absence of a court-enforceable consent decree, we would litigate this matter. Let me come back.
Attorney General, you say that you're doing this to protect the rights of Ferguson residents. I'm wondering, do you think that the City Council of Ferguson is acting in good faith to do the same thing?
I'm not going to characterize their actions because, again, I haven't spoken directly with them. But I will say that this matter is one that has gotten a lot of public attention, so I think you're able to observe how it's been conducted. I think you'll see that both sides have spent a great deal of time thinking very deeply about how to manage the situation. The Department of Justice has provided assistance in an attempt to start the managerial process, certainly of the police department. And so our hope and our expectation had been that we would be able to continue that process with a consent decree. And as I said before, we're disappointed that they've made a different choice.
Following up on Devlin's question about the process, you guys will continue, DOJ will continue to negotiate presumably as you do in any litigation. So is it not the negotiation that's the issue? Is it more the process that we had a deal and the deal says you voted through or you get sued, or is it a legitimate sticking point on their negotiating points? Do you see? I guess that's my question. Is are you suing because their sort of counteroffer is no good, or are you suing because there shouldn't have been a counteroffer?
We're suing because at this point the negotiations were concluded, and the agreement between the parties was that the City Council would review the agreement that had been struck by both sides and decide whether to accept or reject it. And last night's vote was a rejection of that. Whether or not there'll be further negotiations is something that I really can't speculate on. We will proceed with litigation, and we will anticipate the city to respond in court. Amen.
I'd like to ask you about something in pop culture that's got a lot of people talking about these issues. Beyonce has released a video that obliquely references two DOJ cases, the death of Michael Brown and the death of Trayvon Martin. It's gotten a lot of criticism from police. Have you seen that video, and do you have a reaction to it?
I have not seen the video. I saw her Super Bowl performance, so I can't comment on the video.
Good performance?
I thought the performances of all the artists at the Super Bowl were great. Coming back to this.
Big news.
Everyone brought their specific talents to the field.
Choose your words very carefully. Is disappointment really the right word? Yeah, I mean, I've been at a lot of press conferences. We all have that we're there, and you seem rather fired up by this one this morning. Is disappointment? Is that really the right word?
It is the right word. It is. I think that the city of Ferguson had a real opportunity here to step forward, and instead they've chosen to turn backwards. They've chosen to live in the past, and they've chosen to adopt a means of really ignoring the voices of their citizens. They're choosing to ignore the complaints of their citizens, and they're choosing to ignore the clear findings that this department presented to them almost a year ago in March of last year, in March of 2015. They had many opportunities to deal with this, and we had hoped that they were on that path, as we hope that every jurisdiction is on that path. Our view was that we were moving towards a system and a process in which we could work together to create a better Ferguson for everyone, and I am profoundly disappointed that they've made a different choice. All right? All right, well, thank you all.